I used to work at Wilson Sonsini, one of the most renowned big law firms in Silicon Valley. Wilson Sonsini has been responsible for helping startups ranging from Tesla to Apple to Google from their very earliest days when they were still in garages all the way through their financings, IPOs, and eventually helping them with their public company regulatory work. Wilson is one of the most renowned firms that helps technology companies, which is what drew me to work with them because I'm a California boy. I love innovation, I love the spirit of technology, and I wanted to work at a law firm that serviced those clients. But what did I actually do as a general corporate attorney at this firm, and what do Silicon Valley general corporate attorneys do, broadly speaking? That is the subject of this video. Smash that sub button, let's get started. The first thing you should know is that I was a general corporate lawyer when I was at Wilson. What this means is that I didn't focus on one specialty area of corporate law, for example, mergers and acquisitions or bankruptcy. Instead, my practice of corporate law encompassed a lot of different types of work. And what I'm talking about is helping startup companies, helping companies go public through their IPO processes, doing research and regulatory work for companies that are already publicly listed on a stock exchange, among other types of random corporate work that would come across my desk. Already, this is something that differentiates Silicon Valley lawyers from, for example, their New York big law firm counterparts who are doing a more specialized type of corporate work. For example, at firms like Skadden or Kirkland & Ellis or Wachtell Lipton, some of these most notoriously famous and prestigious law firms based out of the East Coast and the Midwest. These firms will have their associates focus very deeply on one type of corporate work. Sometimes that's the financial sector and understanding the various rules and regulations that are affecting banks and hedge funds. Other times it's being purely a deal attorney doing only mergers and acquisitions. But very rarely do junior associates and mid-level associates at these law firms have a general corporate practice where they're doing different things every day for different clients. Now, when it came to the work itself, helping a startup company could be doing something as simple as incorporating a client's startup from the beginning. So I had founders who came to me, and I still do, by the way, with my law firm For Creators by Creators PC, where we represent startup companies. I would have clients that would come in and say, hey, I have this really cool idea, but I have no legal entity or paperwork. Can you help me? And my job would be to incorporate their company in Delaware, get them set up with an initial set of bylaws and board actions and stockholder consents and confidentiality agreements, all of the things that lay a foundational legal framework for their business to be successful. These were the clients that, as a Silicon Valley lawyer, I had the most autonomy and direct relationship with. Because they were the relatively lowest stakes clients, partners and senior attorneys were happy to hand off the relationship to the junior level attorneys like myself.
Rich. Lawyer, not lawyer. I got you.
And the work was pretty straightforward. It was a lot of legal paperwork, but ultimately it was a similar exercise every time. After I got the information I needed from the company, I knew what forms I needed to fill out, and then it was just a matter of doing it, reviewing it, having a senior lawyer sign off on it, and then getting it on file with the various states that we needed to. So that's the earliest stage company work that Silicon Valley lawyers typically do. It's getting the company off the ground. The second stage is helping these startup companies raise money through venture financings. As you may or may not be aware, when you're trying to build a Silicon Valley style startup, a lot of the time, these companies are making a big bet on profitability later on in their life cycle, which means for a long time when they're still building the core of their business, they're losing money, they're not profitable. And the way that they can actually pay employees and grow their business even though they're not profitable is by taking in money from venture capitalist funds like Andreessen Horowitz or Sequoia Capital, to name some of the most famous examples.
Thank you for meeting with us. We have a bunch of these things to go to, hopefully with more tasteful artwork. And your logo looks like a sideways vagina. I find that to be racist, don't you?
Who, in exchange for giving these companies thousands and sometimes millions of dollars, they receive an equity stake in the startup. Of course, the justification for the venture capital fund is that eventually when this company grows and grows and grows and goes public, their return on those stocks that they purchased well before the company went public will be worth a heck of a lot more money, and there are countless examples of this in the media.
Are there any water fountains in your offices?
I assume.
I own 10% of an app that locates all nearby water fountains. I'd be happy to discuss it with you once.
Good day, gentlemen.
You smoke weed?
But as a Silicon Valley lawyer, my job a lot of the time was handling these venture capital financings. And that looks something like this. A startup client would come and say, hey, we have a term sheet for a Series B financing, and Andreessen Horowitz wants to give us $2 million, and then a bunch of these other investors want to give us collectively another $1 million, so we're about to get $3 million in cash for our business. My job for them would be to draft all of the underlying financing documents that would effectuate that transaction. And there were 5 main documents that I would have to draft: an updated certificate of incorporation, an investor's rights agreement, a voting rights agreement, a right of first refusal agreement, and a stock purchase agreement. Each of these agreements has a separate role and responsibility in the broader process of a venture financing. For example, the voting rights agreement will typically state that the investors are promising to elect 1 board of directors seat, whereas the founders have the right to elect 2 people to the board of directors. Likewise, the investors' rights agreement spells out specific rights that these investors are being granted. For example, do these investors have the right to have an observer at board meetings? Do they have the rights to look through the company's files and documents? And there are a lot of other documents that you have to draft in a financing besides these 5, but those are the main ones. So helping a company with a venture capital financing involved drafting all of these documents. Of course, that means getting them reviewed by the senior lawyer, sending these to the other team's attorneys who then will edit them and negotiate them. We then have to correspond with our client and figure out where's the middle ground here for what term we're willing to give and what terms we're okay keeping. And eventually, it's shepherding this process to a close. So not only did I draft these documents and then correspond via email to 100 different people, it's a lot of like project management in that regard and less legal expertise. But as the process moves closer and closer to a closing, my responsibility was to keep track of every moving piece to make sure, for example, that we had every signature that we needed, or that every investor was signed off on a last minute change that we made to one of the documents. Again, a lot of project management in that way. At the same time, these deals were pretty fun because they tended to be fairly simple and everybody was happy with the deal. The investors were excited to be working with this company and hopeful about its future success, and likewise the company was happy because now they have more funding that they can then pay their employees and expand their business with the money.
$1 million isn't cool. You know what's cool? You. $1 billion.
That's the second stage of a company's life cycle that I typically worked on. It was startup financings. Now, the third stage was when the company gets mature and big enough that they're ready to go public and sell their shares on a public market like the New York Stock Exchange or NASDAQ. This is a big deal for these companies because going public or undergoing an IPO process, initial public offering, IPO, marks a time when the company has ascended from the startup world and is now in the big leagues. And helping a company IPO as an attorney is a lot of fun and also, of course, a lot of work. So as a Silicon Valley attorney helping a company go public, I would do a variety of things. When a company goes public, it has to file what is called a Form S-1 with the Securities and Exchange Commission. And this form is basically a conglomerate of all of the major pieces of information that the government has deemed need to be made available publicly to all investors before the company is allowed to list its shares publicly on a stock exchange. Because there's so much information that needs to go in this form, the responsibilities for each section tends to depend on the seniority of the lawyer working on it. For example, there is a more complex section of an S1 called the business section, which explicitly describes the function of the business, how it operates, and needs to be written in a way that's accessible to the broad public. Of course, the risk here with getting something wrong in this document, and not just the business section, but any part of it, is that an investor who buys shares and then loses value later on, let's say because the company's stock price declines, can turn around and say, look, this is securities fraud because your S1 failed to meet the regulatory requirements of the SEC, and that's why I lost money.
A young startup with an IP lawsuit hanging over its head? I wouldn't want to be a part of that team.
Well, but you are a part of that team.
I'm part of the team that team is on.
So there's a lot on the line to get the S1 perfectly correct. In that vein, my role primarily as a junior associate and mid-level associate working on IPOs ranged from doing due diligence, which is poring through the company's corporate files and records to make sure that we correct anything that needs correcting, like let's say there was a missing signature, or perhaps we didn't approve an employee working or get their signature on a document. And it was also drafting certain parts of the S1, like for example, the director and executive officer biographies. I would go through every single corporate director and officer and make sure that we have all of this information that the SEC required of them. I'd also do what's called factual backup. Anytime a factual claim was made in the S1, we would need to have a verified source underlying the fact that was cited. And this is again kind of like a due diligence exercise, just making sure that we have dotted all of our I's and crossed all of our T's. As the date of an IPO gets closer, the last thing that the group of corporate lawyers do is go to the printers. And this is basically when everyone involved in the IPO process, the underwriting investors, the company, lawyers from both sides, they all gather in one place to finalize the document before it goes on file. These are the times when you may be pulling all-nighters. And that's partially because, unfortunately for corporate attorneys, you are the people that are managing the document itself. So while people who work on the business side can say, okay, we made these edits, now go get them processed, the people that actually have to get them processed are the corporate lawyers like us, which means that we have to then sit there, revise the document either by hand or do so electronically, wait for the printing team to come back with the updated version, check to make sure that all of the changes made it in, and then approve it and circulate a new version to the working group. By this point in the process, everything that I talked about on the due diligence side should be handled. And if something does pop up at the last minute, of course, it's our role to raise that to the senior attorney or our partners and then figure out how to fix it. So taking a company public from a Silicon Valley attorney's perspective, it's a lot of due diligence, it's a lot of attention to detail, and it's a lot of drafting, but not contract or deal work drafting. And what I mean by that is take the series financings we just talked about. The way that you draft those types of documents is by taking a previous version of that company or a different company's deal documents and then updating it for the new terms, updated names, updated dates, updated deal terms. But somewhere between 60 to 90% of these documents remain identical. The IPO process is very different because no S1 is going to look like another S1. And that's because every company is different. Even competing companies like Uber and Lyft will sometimes look to each other's documents for inspiration on how to craft a certain point of the business section, for example. But at the end of the day, it falls on the judgment of the supervising lawyers and the attorneys drafting the provisions of these documents to figure out how to best frame what they're trying to explain to the public. And that means more critical thinking, more research, and more open discussions with the company and their business and management team on how to best frame these issues. And finally, the last bucket of work that I did as a Silicon Valley lawyer is public company regulatory work. Full disclosure, I had no idea what this type of work was when I entered corporate big law, but it quickly became one of my favorites. And the work typically looked like this. You had a company that, let's say, you took public 6 months ago, and now they're publicly traded, and because they're publicly traded, the Securities and Exchange Commission has specific rules on filings that they need to make every quarter and once a year. These are called Forms 10Q and Form 10K, and in these documents, they need to provide certain disclosures to the public. So our job as the corporate lawyer was not only to review these documents from a common sense writer perspective and make sure everything is clear, there's no mistakes, but more importantly, it's to make sure that these documents are meeting every single requirement that the SEC has said is needed to be on these forms. What that would mean in turn is going to the SEC's website and looking at their Form 10Q. Once I have that form in front of me that lists all of the requirements and the rules, I would then open up the company's draft and I would go line by line to make sure that whatever the SEC is requiring that we have provided. This would in turn require me to go and actually research past 10Qs that either my company or other companies have done, and also read and understand the regulations and rules of the SEC. So unlike the other types of deals we've talked about in this video, there's not a lot of drafting when it comes to public company regulatory work. Instead, it's more research focused and statutory analysis based because you're actually reading these rules and regulations and you have to comprehend and understand how they impact your clients' needs and documents. The thing I liked about public company regulatory work is that it was very predictable and stable. You really didn't have to pull all-nighters that often, and you knew when to expect these documents to come in because these companies were on a quarterly cycle. So every quarter, every 3 months or so, you know, okay, my client's gonna send me a Form 10Q this week for me to review. It's gonna take me like 3 to 5 hours. In that way, it was a lot more easy to schedule my life around the job compared to things like an IPO process or a venture capital financing that can pop up out of nowhere and then suddenly take over your life for like a month. In conclusion, as a Silicon Valley lawyer, you are the go-to attorney helping these startup companies develop and grow themselves. You are advocating and representing them pretty much in every legal arena that they're in. The corporate lawyers for these companies are often called the quarterbacks because not only are they the point person responsible for helping shepherd these deals that these companies have to a close, but they also act as liaisons between other specialist attorneys like IP lawyers, patent lawyers, or even litigators that these corporate clients may need in the course of their business lifecycle.
I got you a top shelf litigator.
Okay, so how much?
This whole thing is gonna cost you 2.5 million tops.
What?
I know, right? It's like it's free. I told you, I pay for myself.
And in the same way that these startup clients are bucking the status quo by innovating the way that work is done and the way a product is delivered or sold, so too are the firms that representing these firms changing the way that these attorneys can practice law. Silicon Valley lawyers like myself tended to have a ton more early responsibility opportunities than our counterparts at New York-based big law firms did.
Hello?
What's up, Richie Rich? Great seeing you last night, buddy. Just wanted to let you know I had my associate draft up everything like we talked about, and it is all good.
At those firms where clients were as huge as JP Morgan Chase or Wells Fargo, the relationship with the client was pretty much siloed up to the partner level, and down below, you didn't have any sort of direct contact between junior attorneys, mid-level, even sometimes senior level attorneys with the clients. Of course, in Silicon Valley, that's completely not the case. As a junior lawyer, I was working directly with my clients basically from day one. Sometimes working at these firms has been referred to as learning how to fly after you jump out of the plane. And that's getting at the idea that you have to just kind of learn as you go, and you're gonna be thrust into it early on in your career, so you gotta figure it out. I personally loved that. It allowed me to develop my judgment as an attorney and learn a broad set of skills that I ended up later on leveraging to open up my own shop for Creators by Creators. The reason I had the confidence to go out and strike out on my own was because I had all of this early on experience and direct exposure to working with clients and handling deals on my own at Wilson Sonsini. Of course, other Silicon Valley law firms are comparable as well. I'm talking about Cooley or Fenwick or Orrick. I don't think that I would have had those skills if I went to a New York-based firm like Skadden or Kirkland and worked there for 3 years. So I'm personally very grateful for my experience as a Silicon Valley lawyer, and I hope that this video helped give you some insight into what it's like to be a high-power lawyer out there in Palo Alto. If getting into law school is your goal, I highly encourage you to check out my comprehensive 30-page guide to getting into law school. I made it just for you guys, and it is the price of a cup of coffee. The goal of the guide is simple. It's to get you into law school, and in that guide, I walk through every single part of the application process and how you can best optimize your chances at crushing it to get into the school of your dreams. Every single dollar raised through this guide, it goes back to support the content that we are producing on this channel. Smash that sub button. I'll see you around, and thanks as always.